How many of us know, and we have almost accepted it as part of our social order, that no noise in public places after 11 o'clock? Who is the creator? Who is the inventor of that idea? It was Justice Lahoti in Noise Pollution Matters. But I have today been given the task of taking you through some of his judicial decisions. And I would concentrate on only 3 of those decisions because slightly selfish interest on my part, because I appeared in all 3 matters before him. So the first one is, of course, according to me, one of the finest judgments of Justice Lahoti, which is P.A. Inamdar. Inamdar was a bench of 7 judges, Justice Lahoti presiding over the bench, and it's one of those rare occasions when, in a 7-judge combination, it's a unanimous judgment. So to convince all of his colleagues to take them together and then come out with a unanimous judgment itself is a great skillful art. And what was the context? October 2002 came the judgment in TMA Pi, 11-judge combination. There were about 7 judgments. And it created a flutter when it comes to educational institutions and their rights and what exactly can they do. So much so that within almost about 7 to 8 months, the Supreme Court had to constitute another constitution bench to deal with the issues which arose as a result of TMA Pi, and judgment in Islamic came. Mind you, 4 of the judges who constituted the bench in Islamic were part of TMA Pi. And they came out with the idea which is called Fee Committee, Fee Fixation Committee, and Admissions Committee to be presided over by judges of the High Court in respective areas to guide so far as all these issues are concerned. Many felt that perhaps the essence of TMA Pi was getting lost as a result of Islamic. So therefore the matter again got referred to 7 judges, and that's what P.A. Inamdar was. And in Inamdar, at times we are judges or the judicial fraternity is criticized on one count that you are judicially trying to legislate something. So therefore, one of the ideas was that how can the judge-made law constitute a committee of fee fixation and admissions committee? Is that not laying down principles of law? So are you not transgressing the power? And Justice Lahoti at the end of that judgment says that yes, we have to act at times. Why? Because out of those 3 elements which we saw here just now, 3 pillars of democracy, executive, legislature, and judicial wing, if the other 2 wings do not act, then the judiciary has to act. But what we do is always subject to whatever be the legislature and whatever be the voice of people, which will get the sort of, implementation through the legislation. So long as the legislature doesn't step in, we have to act. And that's a very beautiful passage at the end of that judgment in Inamdar. One of the issues in Inamdar was whether there can be a reservation policy in a non-aided institution, whether it is minority or non-minority. And Justice Lahoti's judgment deals with that, and he said that there is nothing in the Constitution which will enable to work your reservation policy in a non-aided institution. If you receive aid, there is always the alter ego of the state which stands behind that institution, and therefore you can certainly work your reservation policy. But in an unaided or non-aided institution, it's just not possible. Of course, the Parliament stepped in, and 93rd Amendment brought in what is called 15(5), which to certain extent tried to water down the effect of that judgment. But Inamdar has stayed, and Inamdar has been the law of this country since 2005 for last 20 years, and it has guided all the non-aided institutions and has guided this particular sphere of activity like the beacon in a cold night. The second judgment which I may place before you is Bal Patil, which I had the occasion to argue. Justice Lahoti was presiding over the bench, but the judgment is written by, I think, Justice G.P. Mathur. No, judgment is by D.M. Dharmadhikari, sorry. And what was the idea? There was a section of population somewhere in southern part of Maharashtra who were practicing Jainism as a religion, and according to them, Jainism should be declared as a minority religion. And the moment you have a declaration as minority, there are certain rights under 29 and 30 of the Constitution which will spring, and so therefore they would certainly have the protection. The idea was simply that. But the discourse and the kind of interactions which I had with Justice Lahoti during the course of that matter actually taught me so many things. His idea was that if we start declaring every section of the population to be a minority, wouldn't there be a mutual distrust amongst the sections of the population? And would it not be that we'll be dividing the society? It is true that, and he also reminded us that the religious kind of, distinction, and on that basis, the differentiation and giving political representation was one of the reasons for the partition of this country. So therefore, should we enter into that arena? Should we embark in that direction? And that's exactly why our submission was rejected. Bal Patil got dismissed. And though some of the observations in that judgment are very, very telling, and this mutual distrust, etc., finds a particular mention in one of the paragraphs of the judgment. The third judgment, Sarbananda Sonowal. There was this legislation which was enacted by the Parliament called Illegal Migrants Determination Tribunal Act, IMDT Act. What happened is after 71 war, there was huge influx of Bangladeshis in the northeastern region. And therefore, to identify some of those illegal migrants, the act was enacted by the Parliament. But what was actually the apparent, the result was that the earlier regime which was put in place as a result of foreigners' determination tribunals regulations was much more severe than this IMDT Act. So therefore the court said that your intent appears to be to stop the illegal migrants' inflow in the country, but the regime that you have put in place is completely inadequate to deal with that problem. And in that judgment, there are 2-3 beautiful passages which are, what is the function of a king? Which was given by Arthashastra in Kautilya's Arthashastra, that a king has to protect not only from the external aggression, but internal disturbances as well. And therefore, according to that judgment, it is the duty under Article 335 of the Constitution of India, duty which is given to the Union of India to protect every state from internal disturbances as well as external aggression. And if that is the duty, your IMDT Act does not fulfill that. So therefore, for the first time, on the anvil of Article 335, a legislation was struck down by the Supreme Court. And according to them, if the integrity and the security of Northeast region is to be protected, this influx must be stopped. And therefore, whoever are the illegal migrants, you must identify them with clarity and take appropriate steps. Now, this is where, again, the ideas of what? One part is, I told you Bal Patil, so that we should not have internal, again, divisions amongst the society. The second part is there should not be internal disturbance in the society as a result of any external aggression. Aggression cannot be just about armed rebellion. Aggression can be in the form of avalanche of illegal migrants as well. So that shows you the kind of attitude which this person had so far as the unity, integrity of this country is concerned, and to what extent that particular bastion has to be guarded. And that was the clear message. And that's the reason I picked up just these 3 judgments in order to place my short submission before you.